Thank you very much, Professor Walters, and welcome everyone to this second panel of the RECONNECT annual conference on the rule of law challenges that the EU faces. Now, over the past years, debates on the rule of law have acquired a greater sense of urgency. And indeed, rule of law challenges are higher on the EU's agenda than ever before. Now, our distinguished speakers will be asked, or were kindly asked, to address institutional suggestions regarding the rule of law. What are the tools that we are missing, if there is anything that we are missing? How to enforce the rule of law in the member states in a more efficient way? They were specifically asked to reflect on the Commission communication from the 3rd of April this year to strengthen the rule of law, but also to specifically address suggestions by other institutions, such as, for example, how could the EU Council-led peer review mechanism work? Or an alternative question is the May 2018 suggestion from the European Commission to come up with confidentiality when protecting the EU's budget connected to the rule of law. How could that work? What are the implications and what are the trade-offs? But we are not only focusing on the EU institutions themselves, but we look beyond and see how other actors, such as, for example, the Council of Europe's Venice Commission, or the OSCE's Office for Democratic Institutions and Human Rights, could be more actively involved in enforcing the rule of law in the EU and its member states. Finally, panelists will be asked also to address the situation on the ground, focusing but not limiting themselves to the member states which are currently subject to Article 7.1 proceedings. Now, the structure is as follows. I will kindly ask the speakers to stick to 5-8 minutes each. And after the 5 introductory remarks, the floor will be open to the audience. And now it is my privilege to introduce 5 speakers of this panel. First, Professor Laurent Bache, professor at Middlesex University, London, and also Jean Monnet Chair of European Public Law will talk. Then Professor Paul Blockers, professor in sociology at the University of Bologna, will share his thoughts. It's also a privilege to have Professor Veronika Bielkova, who is member of the Venice Commission. Mr. Nicolas Berg kindly agreed to join us as well, who is Deputy Head of Unit at the European Commission responsible for fundamental rights and the rule of law. And last but not least, my fellow alumna, Dr. Marta Pardavi, who is co-chair of the Hungarian Helsinki Committee, will share her thoughts with me. So without any further ado, Professor Bache, may I kindly ask you to introduce your remarks. Thank you.
So thank you very much, Petra. So I think I was given up to 8 minutes, so let me try to answer just 4 main questions in my 8 minutes. First question is, what is the nature of the rule of law challenge we're facing? Second question, what has been done in the past 5 years? Third question, what we should expect for the next 5 years? And then last question, very briefly to be addressed, is, do we need a new rule of law instrument? So first, back to the first question, what is the nature of the rule of law challenge, or the main rule of law challenge now currently faced in the EU? I refer quite often to this challenge as the rule of law backsliding challenge, but you have many different concepts being used to describe more or less the same process. What do I mean by rule of law backsliding? I mean essentially the deliberate dismantlement or capture or weakening or hollowing out of checks and balances by national authorities. So this is a process to make the rule of law worse. And it's a deliberate process, so this is not happening by chance randomly because of the lack of resources. There is a deliberate intent to dismantle checks and balances. What is the long-term goal? The long-term goal is to create essentially a de facto one-party regime. So you have regular elections, but these elections are no longer free and fair, and therefore I refer you then to the presentation by Professor Kellerman. Essentially, we're talking about autocratic regimes, electoral autocracy, different concepts are being used, but this is what we're talking about in the EU. This was not supposed to happen. We were supposed to scrutinize, each member state was supposed to be, before becoming a member state, was supposed to be scrutinized as regards the rule of law, democracy, respect for fundamental rights. So to a large extent, this is a new challenge. It's difficult in my minutes to give you a flavor, but just let me give you some concrete examples of rule of law backsliding. It means ignoring rulings of a constitutional tribunal, not publishing them, appointing judges in the middle of the night in open breach of the constitution. It means calling civil society activists traitors through pro-governmental media outlets. It means threatening to sue academics for the content of their scholarship. It means threatening judges for referring questions to the Court of Justice under Article 267 of the TFEU. These are not fictional examples. This is happening as we speak. So first answer to my first question. Now, what has been done in the past 5 years? A lot, actually. If you had asked me if we had met 5 years ago and you had told me 2 member states would be subject to Article 7, paragraph 1 of the TEU 5 years later, I may have struggled to accept that it would happen. We have now in the pipeline also a huge number, a significant number of preliminary rulings raising questions, again, which are quite unprecedented. We have some, infringement actions. Infringement actions initiated by the Commission, a lot of them are raising difficult, unprecedented issues, respect for academic freedom within the member state. I'm talking here about the forced expulsion of the Central European University, raising issues about fundamental issue which we never thought would have to be raised in the context of the EU legal order, about the compatibility of a disciplinary regime for judges, which essentially subject them to a control of a political nature regarding the content of their rulings. I mean, we're talking about at least one member state where a national authority can interfere at will, essentially, with the judicial output. Now, how can we have mutual trust in our system when we have essentially at least a national legal framework where judicial output can be interfered with at will by national authorities? So a lot is happening in terms of the infringement actions. We have seen also quite an unprecedented number of resolutions adopted by the Parliament, European Parliament, regarding the rule of law situation in a number of countries. I'm not going to go through them, but there is a lot. Again, 5 years ago, we would not have seen that. We have seen extensive collaboration between, at least the European Commission relying on the expertise of the Venice Commission, again, something which possibly we didn't expect to see 5 years ago. We are now essentially seeing the Court of Justice stepping into the fray, and for the first time, just a few days ago, we saw the first member state to be found in breach of the principle of judicial independence by the European Court of Justice, the Commission versus Poland case. I shall refer you to, if you want to know more about this ruling, very important ruling, to the RECONNECT website. The latest blog post will give you a very exhaustive assessment of the importance of this ruling. This is only one of the many rulings you can expect over the course of the next 6 to 12 months. So moving on to my third question, is the situation going to get better in the next 5 years or worse? I think winter is coming, and winter is coming sooner than expected. I expect we face 2 potential outcomes in the next 6 to 12 months, either creative non-compliance with what I expect to be adverse rulings from the Court of Justice regarding the rule of law situation in at least 2 jurisdictions, or we may also face an open refusal to comply with rulings of the Court of Justice. We don't know which way it's going to go, but from what possibly I'm overly pessimistic, but I'm foreseeing an open major conflict between at least one member state and the Court of Justice. What we're seeing as I speak, we're seeing at least in one member state and members of the Court of Justice being delegitimized by not only national authorities but also by the media. So this is kind of a process of preparation, I think, for the population to accept that at some point we may have to refuse to comply with rulings of the Court of Justice. I mean, we are seeing now national officials saying that EU judges or EU Advocate General are not independent or that they don't know about EU law. Yes, this is where we are, 2019. My time, I'm sure, is soon to be exhausted. So moving on to my fourth and final question. Do we need a rule of law, an additional rule of law instrument? I can be very brief. Why? Because I have a policy brief on the very issue to be found on the website of the RECONNECT project. This policy brief was written with Petra and many other RECONNECT members. Also, Dan participated to the brainstorming which led to this policy brief. If I had to give you a very brief answer, do we need a new rule of law instrument? I would say possibly, but not at the cost of not using what we have already. I would say if resources are limited, if time is of the essence, I would say let's not reinvent the wheel. I would say what seems to have been working more than we thought would. Infringement action, traditional infringement action. I'm sure Mr. Bell will tell us more about infringement action. But look at Commission versus Poland. A lot of people were quite skeptical that we could put an end to the purge of the Polish Supreme Court. Sorry, I said purge, I meant reform of the Polish Supreme Court. And yet we were able, through a very swift action by comparison to historical precedents, to get essentially to at least prevent the implementation of this so-called reform of one top court. But this is, I'm afraid, so possibly this is the way to go. More infringement actions, application for interim measures, so then the facts on the ground do not change before we get the final ruling. If anything, if we had to add anything to the current toolbox, I would say possibly I would lend my support to the draft regulation adopted by the Commission in May 2018 about potential suspension of EU funding in situations where we have a generalized deficiency as regards to the rule of law. That is possibly, arguably, the last instrument missing, even though some of us have been arguing that in fact you can already suspend EU funding on rule of law grounds, but possibly not explicitly based on the current legislation. So it might be better from the legitimacy point of view to have an explicit regulation, because this would be quite dramatic, but potentially effective, at least regarding one country which is now subject to Article 7, paragraph 1. And which has been described not by me, but by a lot of authors as the EU's first mafia state. So thank you very much. My time is up.
Okay, I'm going to make a couple of comments that I think are additional to what Laurent just said. But I think they help us also a little bit to zoom out somewhat and to think in a broader way and perhaps a more historically sensitive way of what is going on. So I understand your calls for urgent action as sort of putting out the fire because the house is on fire. But I think, and particularly being a political sociologist with a historical sensitivity, I think we should also try to think, how did we actually get here? And what does it tell us also about European policies in the past? So I fully agree, and that would be my first point regarding the main challenges that the EU faces at the moment. I fully agree with Professor Kellerman's argument that the usual suspects are there, the Article 7.1 countries might call them by now, but there are other very problematic cases in the region. Indeed, the Czech Republic, Romania has been mentioned, Slovakia might be definitely on that list too, Bulgaria. And so, if we put it in those terms, I think we really should be starting to wonder what happened there? What does it tell us about the enlargement policy, but also in a more complex manner, and that's where I've been working on most myself. What does it tell us about the so-called post-communist transformation, the democratization processes? Did they all go off track all of a sudden? I don't think so. And so I think we need to, even if we want to have very urgent, clear policy instruments, we need to be able to ground them in wider perspectives. Also because maybe even already tomorrow we need a more robust policy. If a wider number of member states is indeed going off track, we need something that's less than ad hoc stepping in. And so, well, particularly focusing on Central and Eastern Europe, I would say, you could say these countries are both facing very general challenges to the rule of law, and come back to that in a second. But at the same time, of course, what has happened there is fairly unique. It has an awful lot to do with the particular trajectories that they took after 1989. I would even claim with developments already much before 1989, which are not unrelated to what is going on right now. So if you think about a couple of the current clear additional cases, I've been talking about before with my colleague here from Charles University, The Czech Republic fit the bill, and the Czech Republic is in great turmoil at the moment. One of the things that strikes us, of course, there is that ANO, the governmental party currently, it already came to power in 2013. Many political scientists see that as a big change within the party system, within the post-1989 democratization process. Of course, what happens there is a president who has been re-elected might team up with the current Prime Minister Babiš, and according to some observers like Jiří Příban, for instance, from Harvard University, a very astute observer of the Czech Republic, might team up and do fairly similar things to what is by now the script of the populist or the soft autocrats, you might want to call them. And of course, some of the recent things done by Babiš himself, particularly with regard to the Minister of Justice, seem to be already echoing some of these so-called judicial reforms we see elsewhere in the region. Romania is an equally interesting case. We know that case already from 2012, where there was a big turmoil around the government, the president, and the constitutional order somewhere in the middle. But now, of course, it has been at least since 2 years in a great situation of tension around the government that tries to lower the standards of fights against corruption, mostly because of the soft autocrat that then Kellerman showed as well as Dragnea. The Romanian case is particularly interesting, I think, because it goes back much further. I've said this on numerous occasions, I think, but if you look at the first PCD government in the early 1990s, I think we would now describe that as just populist backslide. It proposed an original democracy, kind of one-party state type of democracy. And the current PCD is an inheritor of that party. It's the same party, basically, it changed over time, etc. That's something to think about as well, I think. But very briefly, the key challenges then, it seems to me, is indeed has to do with the rise of these populist parties, and the PCD is not a new party, but it, in certain ways, had this populism I mentioned already from the start, you might say. These projects of judicial reform, a general shift, I think, to what you could call with Nadia Urbinati's terms, a kind of radical majoritarianism, which we need to take into account, I think, in the context of the rule of law crisis. And then a final word on these challenges. One aspect that seems to be extremely important, and that we seem to be a little bit overlooking when we particularly focus on the rule of law, is that, yes, the rule of law is in crisis, but perhaps more importantly it's politics that is in crisis. It is populist parties that are not actually allowing for more politics, they're even reducing politics more than before. And so one of the key questions then becomes is, if you fight the fire currently, what is going to happen after? Who are the political subjects who take up the fight pro-liberal, democratic, rule of law types of institutions? And a further dimension to that is that it seems to me that we need to carefully study what I would like to call a kind of populist legal mindset that we see diffusing throughout not only Europe, by the way, but it's increasingly present in many different European countries. Of course, it has to do with the critique of international institutions. The Venice Commission is this very nasty report by experts hired, so to speak, by the Polish Parliament against the Venice Commission, and it's really aggressive language. But you see that in many different cases, even in my own country, the Netherlands, similar types of critiques have been raised in the past. Part of the populist legal mindset is, I guess, also a very skeptical view towards human rights. How do we deal with it? What does that mean? How can we reinvent human rights again in a more integrative language? And then finally, what I find is extremely important is the way the rule of law is being replaced. By some scholars would argue it's replaced by a kind of law and order idea, which is all about the suppression of dissidents, the suppression of politics all the way through, I would say. If the chair allows me, I would have a couple of very brief remarks on also in a more an analytical manner on the instruments we have and how we might want to think about these. Well, one thing that strikes me is that almost all of the proposals on the table are a kind of reproduction of the conditionality logic that we know from enlargement. But shouldn't we be accepting, at least to some extent, that the enlargement conditionality has not really worked? And so why are we reproducing that same mindset, that same rationale again? Is that a smart move? I'm not entirely sure. Another element to that is, and Wojciech Sadurski has drawn attention to that in the past in his work on, where he says the conditionality process did lead to kind of democracy dividend, but when does that work? When you find a coalition of the willing on the ground. So if you have domestic political forces be willing to actually put through the right reforms, etc. So what does that mean in our cases? Where are these forces? I mean, I think both Hungary, perhaps to a lesser extent, Poland, and it could go for other cases as well, I wouldn't readily see those forces that then will help us, after the fire has been put out, to put the house in order. So how, I don't have ready-made instruments there of how to address that, but it does drag in political parties, but also civil society, and these types of matters. And so I think it's, and maybe I'm misreading that, but in the Commission's recent communication, I read a couple of phrases about we need a more tailored approach. Now I'm winding up. A more tailored approach, and that's already, I think, a very important step in what I think is the right direction. It is a rule of law promotion, but that it takes clearly into account the specific national trajectories, the specific domestic constellations of political forces and so on. The final remark, maybe, returning to these two cases I briefly mentioned, the Czech Republic and Romania, one thing that I find heartening is these youth protests. And particularly in the Romanian case, this is amazing in a way, particularly if you have been looking into the country's democratization process from the early 1990s onwards. And in this case, teaming up in a certain way with Iohannis, the president, who then had the initiative for the referendum, we see real, or potentially real change in the direction of the rule of law strengthening. And this is pointing, I think, to the extreme importance of domestic forces being part of the process, being driving forces actually promoting the rule of law. I keep it to there because I already violated, I think, my 8 minutes.
It was excellent, thank you very much. I think it makes a huge difference. I remember that Professor Sadurski was giving a speech at the stairs of the Polish Supreme Court, and people were chanting on the street, independence to the judges, independence to the judges, and that makes Poland different from the other country which is subject to non-proceeding proceeding. But now let me give the floor to our next speaker.
Thank you for the floor. Thank you also for the invitation. It is really an honor to be here. I'll take a slightly different approach. I'll stay more on the general level. In my 5 to 10 minutes, I want to focus on 2 issues. But before I do so, I would like to remind you of the fact that the emphasis placed on the rule of law is actually of quite recent vintage. It's a bit like in the Cinderella story. So for a long time, the rule of law was in the shadow of its 2 sisters, democracy and human rights. And it's only recently that this has changed. But now, the rule of law seems to be really at the forefront. We see it with the Article 7 procedure. It could be focused on democracy, on human rights, no, but it's focused on the rule of law. And there are different theories trying to explain why this change has happened. And what I find interesting is that most of these theories are not very kind to the rule of law. And they actually draw attention to the deficiencies. They explain the attention paid now to the rule of law by its deficiencies. And it's these same explanations that we often hear as an argument against the rule of law and against the procedure or procedures relating to the rule of law that take place either within the European Union or within the Council of Europe. And I would like to focus on two of these explanations for alleged deficiencies of the rule of law, trying to show that they are either non-existent or somewhat exaggerated or maybe hugely exaggerated. So the first alleged deficiency, and as I said, I would say on a general level, is the lack of definition of or conceptualization of the rule of law, the inherent vagueness of the rule of law. We often hear that it is not indeed possible to have a rule of law scrutiny because no one knows what the rule of law is. So the scrutiny itself is actually violating the principles of the rule of law because we can't scrutinize something that we don't even define. And there are many scholars who agree with this opinion. So, for instance, one scholar has described the rule of law as a much celebrated historical idea, the precise meaning of which may be less clear today than ever before. And I would disagree with these characteristics. I would say that it's the other way around. That today, the concept of the rule of law is much clearer than ever before, and is largely due to the work of international organizations, NGOs, and scholars, including some of my panelists. And obviously, I would like to stress out the importance and the contribution made by the organ that I have the pleasure to represent here, the Venice Commission. Over the past decade, the Venice Commission has adopted two general instruments on the rule of law, the 2011 report on the rule of law, and then the 2016 checklist on the rule of law. The first instrument, the report, gives a list of 6 principles, elements, or components which make up the rule of law as the concept. So it's legality, legal certainty, non-discrimination, the prohibition of arbitrariness, access to justice, and some basic human rights. You can also see that this is quite a thick concept of rule of law which is promoted in this document because it's not limited to procedural guarantees, but it also encompasses some substantive guarantees such as the respect for some human rights. Then the other document, 2016 checklist, provides a list of indicators that actors might use to actually measure the state of the rule of law in a particular country. So we now have a set of not only indicators but also of principles. What is interesting is if you look at these two outcomes, is first that the conceptualization is actually quite concrete, quite precise, at least not less precise than, for instance, what we have for human rights. And at the same time, it largely overlaps with other conceptualizations, definitions provided by scholars, by NGOs, or by international organizations such as the United Nations. So we have the definition or the common understanding of the rule of law. What might be true is that it's not always obvious that we do have it. And so I would recommend to the institutions such as the European Commission, when it deals with the rule of law, it would be helpful to be more explicit, more pronounced, clearer on how it actually understands the concept. And paying just the lipstick to the Venice Commission report, mentioning it in one footnote, is, I think, not enough. So if they really mean it, then they should really work with the report and the checklist and apply these instruments, or rather the content of these instruments. The second alleged deficiency of the rule of law focuses on the institutional framework for the implementation and enforcement of the rule of law. So it is argued that this framework is either non-existent at all, or that it is present, but it's sufficient only for individual shortcomings, but not for what has been described as the rule of law backsliding. And obviously this is noted either with regret or with satisfaction, depending on whether you will continue developments or not. There is some truth to this argument, but I would argue that it's hugely exaggerated, and that goes along the line that the previous speakers have also taken. And it's obviously a very complex matter, so I will just add a couple of thoughts on this issue. So the first thought, I think we tend to underestimate what we have at our disposal, all these tools that we have to enforce or redress the shortcomings in the rule of law, but also all these tools we have to strengthen and promote the rule of law in the countries which are willing to still engage in this exercise, or what we have to diagnose the shortcomings or the deficiencies in the rule of law. And you gave an overview of these instruments. Maybe for the redress section, I would obviously mention the Venice Commission for the promotion, strengthening, and the diagnosis. So we have institutions and mechanisms in place, and we should not underestimate their value. The second thought, I think we tend to panic too early and too quickly. So this is the first big crisis of the rule of law that we see in Europe. And instead of putting really all the instruments that we have available in action, and then drawing some lessons from that, and probably redesign the system later on, we really start panicking and thinking that we should redesign everything at the moment. And I think it's probably too early for that. We should not redesign something that we haven't even properly tried out. The third thought, we should not think that quantity guarantees quality. So we should not think that if we start putting into place new and new mechanisms on the same issue, for instance on diagnosis, that finally one of them at least will work. So we will have the Venice Commission, then we will add the peer review mechanism, maybe an expert panel mechanism, the European semester process, and other mechanisms, hoping that in the end we will get a system. Maybe in the end we will just get a confusion. The fourth issue, the fourth thought, we should be careful whether what is missing are institutions or mechanisms or the political will. And we should not confuse the two, because it doesn't make sense to rebuild institutions if in the end it's the political will which is missing. And the final issue, and that goes back to the fact that I'm here speaking not on behalf but mostly about an institution which doesn't belong to the European Union, but the Council of Europe. We should not forget that within Europe we have quite a rich and complicated landscape in the area of the rule of law. It's not only about nation states, it's also about the European Union, but it's also about other organizations, the Council of Europe, the OSCE potentially. And it seems at the moment that they kind of occasionally reach to each other, but otherwise they live in their separate universe. There's obviously enough challenges for everyone, but I think it would be very unhealthy to proceed in rivalry or a kind of duplications or triplications of activities rather than in constructive cooperation. That is what is needed in this, also in the new framework. Thank you for your attention.
So I'd like to first of all thank the RECONNECT network and the Leuven Center for Global Governance Studies for organizing the discussion of today and for inviting the Commission. In my introduction, I will not go into the details of the situation in specific member states, but rather focus on more general questions from the Commission perspective. Why is upholding the rule of law so important now? What are the tools and instruments that we already have at our disposal to promote and uphold the rule of law, and what could be done to strengthen these tools? And I think I don't need to explain before this audience the importance of the rule of law. It's one of the core values of our Union, referred to in Article 2 of the Treaty on the European Union. It is a prerequisite for the protection of all our other fundamental values, for the application of EU law, for the internal market, for an investment-friendly environment, as well as for mutual trust between member states and their authorities. In a nutshell, it is crucial for the very functioning of the EU, and it therefore cannot come as a surprise that Finland decided to make the rule of law one of the key priorities of its presidency. The developments which have occurred over the past 2 years have only made the Commission more convinced of the importance of using all the instruments that we already have to uphold our core values, and in particular the rule of law, in the most effective way. The deterioration of the situation of the rule of law in Poland led the Commission in December 2017 to initiate the procedure set out in Article 7 of the Treaty on the European Union. In September last year, Parliament decided to initiate the same procedure as regards Hungary, and these are unprecedented steps in our Union. The Commission, as guardian of the treaties, is also using infringement proceedings to address values-related violations of EU law by Member States. And with regard to the Polish law in the Supreme Court, the Commission asked the Court of Justice to impose interim measures, which the Court did, as you know, on 17 December last year. And on 24 June, the Court delivered a final ruling in this case, confirming the Commission's position. And this judgment of the Court of Justice is very important. It clarifies the scope of the principles of the irremovability of judges and the independence of the judiciary, and in doing so it protects not only judges in Poland, but all judges in the Member States of the Union who are called upon to apply EU law. And the judgment also makes clear that although the organization of justice in the Member States falls within the competence of the Member States, the fact remains that when exercising that competence, the Member States are required to comply with their obligations deriving from EU law. And it is now clear that the organization of justice is not the exclusive domain of the Member States. There are other values-related infringement procedures underway that I will not discuss further. And as Professor Pesch already mentioned, there is also an increasing number of requests for preliminary rulings on important rule of law related matters. And all these new cases will enable the Court of Justice to further develop its case law and in doing so strengthen the foundations of the Union. The Commission is also using other instruments, including measures through the European semester, with the help of the EU Justice Scoreboard and of the country reports that the Commission issues to monitor justice reforms in the Member States. Country reports for all Member States were issued this February, and in June the Commission proposed country-specific recommendations, which will have to be adopted by the Council, for 7 Member States on the functioning of their national justice systems and on the fight against corruption. Also, and it was already mentioned, the Commission has proposed as a key component of the next multi-annual financial framework a new regulation on protecting the Union's budget in the event of generalised deficiencies as regards the rule of law in the Member States. The Parliament already adopted a constructive position on the proposal, and in-depth discussions in the Council will now continue under the Finnish presidency. All these actions show the Commission's determination to use all the instruments at its disposal to address value-related concerns, but it's clear that more needs to be done to improve the EU's capacity to promote and uphold our common values. And for this reason, the Commission launched a reflection process with its communication of 3 April on the rule of law in the EU, setting out possible avenues for further action. Communication presented the existing instruments, Article 7, the rule of law framework, infringement proceedings, the European semester, the Justice Scoreboard, and communication also presented the experience gained so far with these instruments. And in the communication, possible avenues for the future are considered in terms of 3 pillars: promotion, prevention, and response. And for each of these topics, the communication provided a set of questions to guide the consultation. The Commission received written contributions, including from quite a number of participants present here today, and further contributions may still be coming. And of course also today's discussions are part and parcel of this reflection process. The input received is feeding into the preparatory work of a new initiative to strengthen the rule of law framework that the Commission intends to present, possibly still before the summer break, but exact timing needs to be confirmed. As a final remark, I would like to recall that upholding the rule of law in the EU is a common responsibility of all EU institutions, member states, international organizations, including the Council of Europe and its Venice Commission, as well as, of the judiciary. But of course, there is also a very important role for civil society, for academia, for think tanks like the RECONNECT network, and in fact for all of us as citizens of the Union to contribute to the present debate and to the promotion of the rule of law as one of the values on which our Union is founded. Let me therefore thank you again for organizing today's exchange, and looking forward to the discussion.
Thank you. It is really a pleasure to be here, not only because I'm a Hungarian and there's been so much talk of Hungary, as always, usually nowadays in conferences and discussions that focus on human rights and rule of law in the EU, but also because it's such an excellent and varied panel, and as a human rights person working for a Budapest-based human rights organization, a civil society organization, I feel very privileged to be able to add my thoughts on my learned colleagues, and I would like to actually contribute to this discussion, complement what has been said. There is a lot of talk about what is the rule of law about, and I was very happy to hear that you said there is already a clear definition. We don't need to go into the definitional debate. One does hear, for example, the Hungarian government, when the Article 7 process was leading up to the Article 7 process in the European Parliament, debate whether there was actually a definition of it. It's quite clear there is. But going beyond the definitional elements is really important, because we do see how today Europe is in a place where it's not only the countries that you pointed out, but many others that potentially are at the risk of rule of law attacks, because this seems to be a wonderful tool, perversely, to undermine both democracy and human rights. And so I, not being an academic, would put aside whether democracy and human rights and rule of law are different, but I suggest that we look at them together and see how they're coming under threat today more than ever, and what are the tools beyond sometimes the legal tools that can help us to prevent further backsliding in certain countries, prevent any sort of backsliding, and promote the idea among citizens so that those societies and countries which perceive that they're still safe today will remain so for tomorrow as well. Now, and it is exactly this where other actors, other than the European institutions, other than courts, other than member state governments come into play, and these, just to narrow them down, maybe a little bit arbitrarily, is civil society and the media. It's very obvious that whenever and wherever rule of law is coming under pressure in Europe, we also see civil society and independent plural media coming under pressure. Sometimes these are the precursors to a rule of law threat. Sometimes these happen in parallel. And no wonder that this is happening, because governance and accountability are beyond the legal system, are also the mission of a good journalist and a good civil society activist and a good citizen. And so, in order to weaken that ecosystem, that infrastructure that could, when other already weakened state institutions fail to perform their role, then you have to go after the civil society and you have to go after the media. So when in places like Hungary, we see all of this unfold. In Poland, we see all of this unfold. In some other countries in Central and Eastern Europe, some of this is coming under pressure, but we also see many of this coming under pressure in Western Europe. And I'd say that asylum and equality are two rights that are coming under pressure everywhere in Europe. The idea that people are equal and that people have the right to protection in Europe is such an overly politicized idea today that we see rule of law pressures being tested in exactly those two areas. So there is a very strong link between civil society, freedom of the media, and also the rule of law, even if it's narrowly defined. And I propose that we start thinking about the rule of law in this broader sense, just as Article 2 goes much further than talking about judicial independence. Also, these are two sectors, the media and civil society, which are crucial in promoting, safeguarding, preventing rule of law abuses, democratic backsliding. We see how the Commission has asked what are the ways that could be introduced or strengthened to promote the rule of law. And obviously it's not the Commission's role exclusively to do this. I remember very clearly when the European Commission did venture very rightfully into the territory of communicating with the public directly, Hungarians, when it had to respond to the very nasty attacks on Commission policies and the Commission's president. And so there was a PDF translated into Hungarian that was distributed in social media. That is, I think, a good endeavor, but it will never actually have that same effect as billboards plastered all over the country. You do need local civil society and local free media to counter this and to expose the lies and to safeguard democratic ideals of participation, pluralism, and debate. And so the Commission can actually help promote this through indirect means, and that would be certainly funding for these efforts and rights, but also not only funding, but by making sure that the enabling rules that allow these rights to be exercised are not coming under pressure, to uphold the right of civil society and media to operate freely so that they can contribute to a vibrant debate. So there is quite a lot already done on this front. Many of the value-related infringements and other complaints already that the Commission has to deal with are focusing on these issues, and they do come from Hungary. And that's also a way to safeguard, but we also have to look at legislation and basically ensure that whenever we think of rule of law, we also think about the pressures to those who could uphold it and make sure that legislation and policy measures don't erode those freedoms and these very important actors. Prevention obviously is a very important role for civil society. We do contribute, it's not only our role, there's thankfully many actors, but we would like to continue to contribute to this. Coming from Hungary and having also put in a reflection paper to the Commission's communication from April with the Polish Helsinki Foundation for Human Rights, we have experienced how sometimes it is easy and sometimes it is difficult to engage with the EU institutions when it comes to rule of law issues. In the case of Poland, the rule of law framework didn't really allow for civil society input. And I think that was maybe a missed opportunity. There's lots of other critical remarks about this, about the rule of law framework, but one is certainly this, that it couldn't build on the wealth of experience and up-to-date information from the ground when it did not open up the doors to civil society to make input. On the contrary, In the case of Hungary, of course, the European Parliament's procedure did allow for this, and it was much more transparent. I wish that there had been a little bit more of reaching out from the Parliament by having a fact-finding mission go to Hungary to engage with a lot more actors, but for various political reasons that sadly didn't happen. That of course also meant that the parliamentary process was, I think, very unduly criticized. Transparency, the ability to engage publicly with the European Parliament's process, of course, also had a side effect, which we didn't expect. And that's a third thing about civil society and its involvement that I'd like to raise here. Interestingly, the more transparent the process is, the more you can engage with it, the more you can be targeted for doing that. It's my personal experience that when I was invited by the Libe committee to address the committee about what is going on in Hungary, that was televised, broadcast live in the Hungarian public media, and my colleagues back in Budapest in the office were flooded with hate phone calls and emails. Our social media pages was flooded while I was still giving my presentation. So we have to be mindful of this, that no surprise, of course, that there's in similar mechanisms, such as the UN human rights system, which has pretty well established mechanisms and models to be inspiring the European Union's institutions too for civil society engagement. The openness, the avenues to engage are complemented by measures to ensure that those who do engage are not put at risk. And that is something that we also have to think about. Sadly, it is very topical today in Europe. Thank you.
Thank you very much for your presentations, and just follow up to what you have just said and to what has also been mentioned in the keynote speech, namely that one of the contributing factors to rule of law backsliding and no change happening is that people are leaving the country. There is an exit strategy. Now there is a group of people who refrain from leaving the country because they live from the language. They live from what is actually happening on the ground, and these are journalists, investigative journalists. So it would be an idea to fund them directly, just like the ideas promoted by the NGO Liberties to fund NGOs directly. The same idea could be taken up, and media sources, journalists, individual journalists could be supported perhaps directly by the European Union if it is legally doable. Now I have a couple of questions. I just summarize them and let you decide which one you prefer to ask. We can choose from them. The first is conditionality. It has been mentioned that conditionality could work without touching any of the treaties, but also any of the secondary pieces of legislation. As you have mentioned, Laura, it would be more elegant to have a separate legal instrument for that, but perhaps if you could just explain how it is possible even without any legal changes. The second issue is the topic of infringement action, which several of you have mentioned. How could infringement actions be made more effective and efficient? We have seen that in some cases, infringement cases are effective, especially now with the recent case law, if it's the judiciary that is effective, and not least because we have a specific provision in the treaties that can be triggered. But what if it's not judicial independence that is at stake, but academic freedom for that matter? I don't want to get personal, I'm affiliated with the Central European University, but we do know that the infringement case on academic freedom vis-à-vis Hungary is still ongoing, but it's soon going to, and it is already moot, because CEU already left the country and the infringement process is still ongoing. So what elements could be inserted into the system so that it becomes more effective? rule of law backsliding indeed SEE phenomenon. I understand that there is this huge body of literature on the democratization process and how it was or wasn't successful, but perhaps if you could elaborate on that. And you had a very important remark that you took for granted, but perhaps if you could go into explaining why acknowledgement conditionality did not deliver. Now, all the tools, or most tools that we have addressed so far, they are ex post facto tools, like infringement actions or Article 7 procedures. But it would be nice to create a landscape for the rule of law and a true mutual trust among the member states, so that the EU can interfere with before the house is actually burning. And one such suggestion has been promoted by the European Parliament in its Pact on Democracy, the Rule of Law and Fundamental Rights, where they plan to monitor all these values and to step in whenever this is needed. Now, there is supposed to be an independent body at the core of this so-called DRF, Democracy, Rule of Law and Fundamental Rights mechanism, monitoring the member states, but some argue that the Venice Commission could take up this role. So my question is, what are the limits of the Venice Commission, or could it indeed actively be involved in this process and take up the role of an EU, strictly and exclusively EU-funded organization? So I stop here and I give the floor over to my RECONNECT panelists and speakers.
So thank you very much. So I guess you wanted me to say something about the draft regulation adopted by the Commission last May, or rather whether the draft regulation is needed in the first place. So I mean, legally speaking, I would just refer you to the studies by Israel Butler, Professor Kellman, and Professor Shepelet, who have been looking at existing secondary legislation. And the bottom line, but Dan can correct me if I'm wrong, and I would agree with their assessment, is essentially you cannot have a system with no independent auditing scheme within the national member state. So essentially, once the independence of the auditing system is under threat or at risk, funding can be suspended. But a case-by-case assessment needs to be made, and there is a lack of transparency, there is a lack of immediate effect. So essentially you could argue, yes, you could do it, but possibly not in a way which will be as efficient and as transparent as the Commission is trying to do in the context of the draft regulation, so to which I would lend my personal support. So it can be done already, but I think regarding the political symbolic importance of suspending funding on the basis of a potential systemic risk to one of the foundational values on which the EU is based and a value which is supposed to be common to the member states, I think we'll be politically and legally better off adopting the Commission's regulation, and I hope that the Council will get its act together and hopefully will find the majority which is required to adopt the regulation. But perhaps Mr. Bell can tell us more about when, if we can expect this draft regulation to be adopted. But the bottom line, I would say, is, and possibly moving on just slightly to whether we need new mechanisms. Again, I think the bottom line I would like to insist is that we have a lot of instruments. Let's use them to the maximum capacity. So let's not try to essentially lose ourselves into reinventing the wheel. It could be that in the medium to long term, yes, a lot of new instruments could be usefully complementing the existing toolbox. But I would say I think infringement actions plus preliminary ruling jurisdiction of the Court of Justice, if the couple Commission, Court of Justice do work well together, possibly at least we can contain what we have referred to as rule of law backsliding. It might not be enough to roll back the changes which have been made, but possibly that's the best way to at least contain what seems to be spreading to increasing number of jurisdictions. What is sad in a way is that it took us about 10 years to get to a point where at least the first controversial judicial reform was actually stopped effectively. But this is just containment, this is not rolling back. So essentially, it's a rule of law backsliding is still very much a threat. And if I had to choose between immediate action based on existing instruments and spending time setting up a committee of experts to look into potential new instruments to the toolbox, I would choose obviously the former rather than the latter. But if we can do both, sure. But what we need for the time being is short-term actions. And that could be my lawyer's bias, but I would say yes, judicial independence is key. We have to preserve judicial independence, because if judicial independence is gone, then it's not simply a threat to the entire national legal system we're talking about. This is a systemic existential threat, not only to the EU's DNA, but to the very functioning, the very essence of the EU legal order. What's happening in a single member state is of decisive importance to the whole EU legal order. So what's happening in Poland is of importance to anyone, anywhere. Yes, we need action in the short term, and possibly new mechanisms could complement this, but not at the price of inaction in the short term. That would be my 2 cents on the question.
I guess I would directly want to take up the question about whether this is a Central and Eastern European phenomenon, which I think, at least I already articulated my view before. I think it's not. It's clearly not. To do a bit of shameless self-promotion, I've got an edited volume coming out on Italy, and I think you could identify in those studies in that book, but also in other studies on Italian populism, so to speak, there are important similarities, and this is, I'm living in the country, I would claim it's becoming almost as urgent as in some of the Central Eastern European cases. I might simply just mention the Sea-Watch case, so to speak, and clearly the reaction by the Italian government is, in my view, echoing some of the judicial reform types of arguments that we've heard so many times elsewhere. So I'm definitely not thinking it is reducible to the Central European or Central Eastern European region. And I think it's also important to draw attention to another aspect that we haven't really discussed yet, but is essential, I think, and it's very complex addition to our discussion. I mean, we talk an awful lot about civil society as a major factor, but let's also talk about uncivil society. And we know how important that has been in the backup to Fidesz. We know how important that has been, and it has been actually a much longer outspun process than we normally assume in a country like Poland. But of course there are similar developments elsewhere, and indeed again Italy is a case in point. And so I think we need to reflect on that further, and while being a sociologist and trying to preserve what is still left of that discipline, I would make a strong case of we need to rethink about how all those important rule of law, I would say in a much broader sense, constitutional institutions, how are they sociologically embedded? If you have large swaths of society adhering to the uncivil society sort of narrative, and their views of democratic or non-democratic polity, you have a clear, huge problem. And I'm very happy that in the debates, and that seems to be recognized by some of the most important scholars. I mean, Kim Shapley is very aggressively, in a way, and rightly so, promoting rule of law instruments, but she also has a second sociological hat, which strongly emphasizes this. And interestingly enough, in the excellent book of Wojciech Sadurski on the Polish case, which is, I guess is the most detailed study at hand, he does admit that ultimately the most robust, formally robust rule of law institutions will not hold for very long if the right professional groups, but also societal groups, are not showing the will and backing up those institutions. So I think that raises important questions, and that's why I like very much the intervention from Budapest, so to speak, because I mean, some of the issues are broader than the rule of law. I really feel that sort of a package of rights related to freedom of speech, right to free assembly. Let us also think about indeed scientific freedom. These are really essential to fight, in a way, the diffusion of on civil projects of different kinds. And so I think we need to, unfortunately, perhaps because of being a sociologist, I don't have ready-made legal, political answers to how to achieve that. And I think it's important to keep in mind and discuss. Yeah, exactly.
I guess the Venice Commission question was for me, so I will first address this one, and then if I have time, I would like to read the two issues that Marta raised that I also found very interesting. So first of all, the Venice Commission, 3 points. The Venice Commission can and indeed has done quite a lot in the area of rule of law backsliding by diagnosing what is happening in certain countries. And I don't think I need to bring to your attention all the opinions that we've adopted on Hungary, on Poland, and other countries. So quite a lot has been done. But there are some limits, and there are also some risks or some price to pay. So first, as to the limits, I mentioned 2 at the moment, but probably there are more. The one is that, and that's a technical or legal issue, the Venice Commission cannot act out of its initiative, so it always needs a request, and the request can come either from a state or from a Council of Europe or the European Union body. So it very much depends on whether there is someone who would like to have an opinion of the Venice Commission. If this is not the case, then there is not much the Venice Commission can do. The second limit is that the Venice Commission has not been designed, and I mean in terms of its statute, but also in terms of its actual capacities or abilities to undertake something like a universal periodic review of the rule of law in all its member states, or maybe only the member states of the EU. That would clearly be beyond not only its mandate but also beyond its capacities. I'm not even sure whether the Venice Commission, provided also that half of its membership are not the EU countries, so whether it would be the best place to do so, because then it could lead to a double track assessment within the Venice Commission, because only the EU states would then probably be assessed in this way. So these are the limits, but there are also some risks potentially for the Venice Commission itself. For the moment, the Venice Commission has been considered to be either a helpful body or a harmless body. And the two characteristics have been rather good for the Venice Commission, because that means that it has not been attacked or threatened. But as was mentioned by Rohan previously, this has recently changed. And now the Venice Commission, because obviously its role is not seen as either constructive or harmless any longer, so the Venice Commission gets under attack itself. And obviously, the higher the role assigned to the Venice Commission, more threats are coming, including the threat of trying to colonize the Venice Commission. There is this well-known saying, who watches the watchers or watchdogs? So we could also say, I think along the lines that Marta said before, who protects the protectors? Then we would need to be able to think also about some protection to bodies such as the Venice Commission. And if I may, 2 comments on what Marta raised. The first one on the financing, and that was both in your intervention and then it was echoed by Petra, and I understand where it comes from because it's a difficult dilemma, but I would like to stress that it is kind of a double-edged sword, because without foreign financing, you don't survive, because normally you don't get domestic financing if you criticize your country and your country is an authoritarian regime. On the other hand, with the foreign financing, obviously you immediately get labeled as a foreign agent or someone who is paid for abroad by the biggest people in Brussels and by Soros in the background. And it might be especially dangerous if this mechanism of cutting funds is introduced, because then obviously the narrative would be, you see, the European Union cuts funds to the country because it wants to spend all this money, not on hospitals and schools, but on vicious NGOs. So that's a very dangerous, that's something to take into account, and it's a difficult dilemma. And the last issue I want to comment on, you mentioned the 3 values which are at the core of the Council of Europe, the European Union, etc. That means human rights, democracy, and the rule of law as complementary. But actually what is interesting nowadays is that those leaders in the backsliding countries try to play these values against each other. And we often see, and it also resonated partly in the debate before, that when they introduce some limits on the rule of law or human rights, they don't do it because they would be autocrats, but because they are actually democrats, because they do what the majority or what the people want. That's the main argument. But then obviously it brings in certain questions like who the people are. Is it only our voters? How do we ascertain what the people want? And finally, if people want something which is at odds with other fundamental values, such as human rights, can be really implemented. And we saw in the previous debate that it's a real issue, and that there are people going in both ways. Let's keep it to this.
We agreed to have 10 additional minutes because we started 20 minutes later than originally foreseen, but I must ask you, with all due respect, limit your intervention so that we can give the floor to the audience.
So, I think addressing rule of law challenges in the EU requires action on different levels: promotion, prevention, and response. And I think a very important development is the fact that the Court of Justice has entered the stage with, first of all, the Portuguese judge's case and the cases that follow later. And in fact, the role of the Court of Justice is very important for all these three pillars. And it's a privilege that we will have Professor Leonard later this afternoon to give us a presentation on this. And the Court of Justice is allowed to enter the stage not only through infringement proceedings brought by the Court of Justice, but also, and very importantly, by requests for preliminary rulings coming from national courts, from the ground. And it is also very important that we protect the right of national courts and to give them unimpeded access to the Court of Justice if they have questions on the interpretation of union law. And as I said before, the cases that are brought before the Court of Justice will allow the court to develop its case law, and that will strengthen the foundations of our union.
That's exactly what I wanted to say. Let's not forget that judges, not only in the courts of justice, but everywhere, who can and should be encouraged and helped with exchanges, professional links established, and these good and interesting practices shared about asking for preliminary rulings from the court. I think that is something that is not really used to its full potential in these cases, partly also because lawyers might not be aware of how useful these tools can be. And so it's very welcome that the Commission does now have a call for applications, had it, because it's already closed, to encourage capacity building on litigation on core fundamental rights issues, because this is something that we found is not used to its full potential, and most human rights lawyers are good in the European Court of Human Rights case law, but not necessarily as good in EU law. And these kinds of experts need to meet more and learn from each other and work together.
Thank you very much. And we have time for 3 to-the-point questions from the audience.
Thank you. Virginia Fiume, I work for Science for Democracy and Humans, and we coordinate a European Citizen Initiative for the Respect of the Rule of Law. So we need to gather just 1 million signatures across Europe for this. So, my question is, the rule of law is the blood of a functional society. that helps citizens to trust the institutions, or at least this is how I see it. I found very interesting, and I'm learning so much from all of you, but my question is, what citizens can do to take part in a process that helps the rule of law to be healthy? So far it seems very analytical and political, but I'm sure citizens can take responsibilities in some way, so I'm interested in your take on this issue. And if anyone's interested in the ACI, here I am.
Thank you very much. Professor Tuzai?
Thank you very much. I just wanted to put a question which you, Petra, already put, but has not really been answered. And that is about how do you see the reform, possible reform of the infringement proceedings? I mean, you mentioned the Central European University case, and I would be really interested in hearing your views about concrete proposals, how it could be possibly reformed, because it's true that 2 years sometimes cannot help, and we have this Polish case, this interim measure case last year, which was a very good signal, but that's the only precedent so far. And I think the two Hungarian panelists could also mention something about the most recent case in Hungary concerning the Hungarian Academy of Sciences. Thank you.
Thank you very much. And Natasha?
Yes, hello, thank you. So, Natasha Dashkin from Open Society. I wanted to come back on a few points. One is on the whole idea of new proposals and do we need new proposals. I completely agree with all that was said, but I wanted to add a point here. Not only is there a risk of leading to more confusion, as the Venice Commission put it, or undermining existing instruments, some of them, and I think what Laurent said is very important, have not even been tested or used. But ultimately, what I see a risk happening recently is that these discussions distract EU institutions and member states from their existing obligations in general, under EU law and these instruments. And it distracts them from their inaction and what they have not been doing. And three things I want to put in relation to this. Right now we see a lot, each institution discussing separately about what it could do to improve its system, but we haven't seen a lot of interinstitutional discussion. What can we do together? How can we, each of us, with our proposals, back up each other, support each other to have some impact? We have really seen very little of this, and I wanted to hear you about some idea of institutional action plan on how you act together. The second thing is about the rule of law and definition and what has been going on. I think we can talk about that a lot, and rule of law and Article 2 is wider, etc. But I think one thing we often don't talk about is the purpose of all this. I mean, why do we care about rule of law at all? And why do we want to preserve that system? And I think this is for, clearly the mind, and I think in explaining and promoting rule of law, that this is to allow the protection of our rights and exercise of our rights. And that leads me to the third point about promotion and prevention. I really believe in these discussions we need to have, and this was said at the very beginning by a discussion, I'm very happy to connect or look at migration, security, etc. If we don't have at the same time a link, and if we keep on hearing politicians telling us rule of law has nothing to do with migration, has nothing to do with counterterrorism or with non-discrimination, I don't think we're going to go very far. And to end on the Sea-Watch example and the first panel, when all these discussions were happening, we had inaction of member states and people dying at sea, and one person who had to actually break the controls of the police to make something happen. And I think this should make us think just as much as all our debates on politics or definitions.
Thank you very much. We have such as we follow a reverse order, if you don't mind. So first one, please.
Well, Professor Tuzai asked about the Hungarian Academy of Sciences, which, if you don't know, I think you should know about it. Very worrying and very rapid development that happened and in the past few months, and basically ended early this week when the Hungarian Academy of Sciences, which was a premier, very well respected institution created in the 19th century, academic freedom, even in much of the darkest times of the last century, has been basically stripped of its assets. There's not much that a Hungarian can now do about it, because the Hungarian parliament has decided so. There's been a lot of protest, but we've seen that this wasn't the first occasion that the Hungarian government completely disregarded these warnings or critical voices. And the question is there anything that the European Union can do about this? And what is it? And what creative ways can be conceived to address this? Are there any? The Commission has so far said that it's looking into this. It's been looking into this for a while. But one wonders, can we in Europe have this happen without any consequences? And if yes, will that happen in Poland? And which institution will be next? There's been 2 cases in Hungary of extremely outrageous rights violations of academic freedom at Central European University, now the Academy of Sciences, and we see how there's not much that has been effective in preventing it or sanctioning it. So, while for many Hungarians this is very removed and it seems like an elitist issue, it is again one of those testing grounds, those experiments that could be adapted basically now, any day, anywhere else maybe. So it is really a big question mark. I can't give an answer on what will happen. And probably a lot of excellent scientists will be leaving, emigrating, and having other academic institutions profit from their knowledge, which is, because we're all Europeans, we're a good thing, but it's a really sad thing for Hungarian academic freedom.
Thank you very much, Isabel.
Yeah, I would like to say something on the involvement of citizens in all the discussions we have on rule of law. And I think it is very important to help raise awareness among the general public about our common values, about the rule of law, about the standards that exist regarding the rule of law. And I think it is very important to not only discuss about infringement procedures, although they are very important, to not only talk about monitoring cycles, although they are very important, but also see how we can bring our common values, the awareness of our common values and their importance for the citizens themselves to the citizens. And that is certainly not something that the Commission should be preaching, but that should be a collective endeavor with an important role for civil society, for academia, and as part of the reflection process that the Commission launched, we are very interested in receiving the input on this, because it is a fundamental part of addressing rule of law challenges in the EU.
I would like to address the first question about what the citizens should do. I would say they should do 3 things. They should know, they should care, and they should act. And not necessarily everyone. Everyone should know, as many as possible should care, and at least some should act. And what I mean by knowing, I don't mean that everyone should read the Venice Commission report and the checklist, though this would be obviously ideal. But they should have the understanding that you yourself gave, that the rule of law is actually something very useful for the society and for themselves. And I'm afraid this understanding is missing, and is particularly missing in Central Europe, and that might be also one of the keys to understand why the phenomenon is more serious in Central Europe. And I've made an interesting survey on human rights, but I think the results would be largely similar for the rule of law, asking people how they see human rights, what it means for them. And there were three main responses. Something very metaphysical, very philosophical, they don't even know what it is. Something political, like something that the West imposed on us in the 1990s, and now when we don't like the West so much anymore, when we reject it together with this affiliation, or something that only belongs to small minorities, but that the majority voter does not associate with, and that's a very dangerous association. So I think everyone should know, at the level that you describe yourself, and also the third speaker, I think that was a brilliant definition, even better than that one of the Venice Commission, I would say. So they should know. As many should care, it means follow what's happening in the society. We can't hope to have everyone politically active or even interested in politics. But if we had at least a strong minority following what's going on and kind of passing the information to the rest of the society, that would be enough. And finally, at least a minority should act. For instance, along the lines that you did with the petition, or along the lines that people now take in my country or in the other ones. That means going to the demonstrations.
Yeah, no, I would fully back that up. I mean, I would also like to respond to that question on trust in institutions. I mean, protest seems a bit of an old-fashioned thing to do, but there's so many instances in which we see that it has a great impact. I mean, completely different case, for instance, would be Iceland, where I think in the last 10 years you've seen a sort of repertoire being sort of institutionalized almost in that sense. So that's extremely important. But I think we should also think much more on the other side of the spectrum. That is, citizens can do things also if there are institutional inroads. And so the ECI is one of those. But for instance, I do quite a lot of work on constitution making and participatory democracy, and there are great many examples of how you can involve citizens. The Irish case is an obvious example, but and so it's also that relationship, I think, that needs to be addressed. In the ECI, I think it is sometimes a bit of a almost wasted opportunity. It could be strengthened much more. It could be made much more accessible, and not only to organized interest groups, etc. And so, and that brings me to the final point, because I guess we're running out of time, but my main proposition would be for a sort of multiple form of constitutional resistance. The Polish case in that sense is extremely interesting. It's civil society groups, but it's also judges organizing themselves together. And that's really the final point. What is essential is that civic mobilization is able to convince, tap into political existing parties, new parties, opposition parties. Without that, it is likely not to have a lasting impact. And that's also something to think about. How do you strengthen it? How do you, some of the funding questions relate to that too.
So very quickly, 2 points. First one on infringement actions, and second point on the preliminary ruling jurisdiction of the Court of Justice. I'm going to answer the question you were asked to answer, Petra. In fact, I might just refer you to the policy brief published on the website of the RECONNECT project. We have a section on infringement actions, and now to make some, in it you're going to find some concrete proposals which are largely based on Petra's latest paper. Regarding preliminary ruling jurisdiction of the court, I would like to concur with Mr. Bell, emphasizing the importance of requests originating from national courts, and the importance of protecting national judges submitting questions to the Court of Justice. I'd like just to add a dimension which we didn't really have the time to take into account, but there is a new threat now, potentially undermining the effectiveness of Article 267 TFU. It's not simply state action, it's private action. What do I mean by that? I would just refer you to the very important report from Amnesty International published yesterday about ongoing disciplinary proceedings against judges. I would ask you to please possibly the Commission should investigate anonymous social media channels are disclosing private information of judges, including judges submitting questions to the Court of Justice. This normally falls off the radar because what we look at whenever we try to enforce a new law, we look at whether national public bodies are complying with the new law. What I'm seeing now is that more and more those wishing to undermine the rule of law not only use quite obvious means of doing so, but when they are subject to Article 7 proceedings, now we're seeing essentially indirect ways of trying to achieve the same means, but through more discrete channels. And this is a new threat which has only emerged from what I've seen in the past 6 to 9 months. So it's important to protect national judges, not only from direct threats originating from public bodies, but we also, I'm afraid, we have to start thinking about protecting national judges when they are subject to threats through essentially from private actors, which may or may not be connected with public authorities.
Thank you very much. My positive takeaway is that the EU already possesses a comprehensive and sophisticated rule of law toolbox. The question is whether we want to use it promptly, forcefully, and in a coordinated manner. We don't end our discussions here, but we suspend it. And I very much hope to continue this debate on the rule of law that will shape the future of the European Union with decision makers, fellow academics, NGOs, and the general public, which is the primary aim of the RECONNECT project, to bridge the gap between the citizen and the union. Thank you very much for coming.